Good afternoon, everyone. Welcome to today's webinar on the state of institutional arbitration in East Africa. My name is Florida Kavasinga. I am coming to you from Kigali in Rwanda. I am the chair of the ADR Committee of the East Africa Law Society. Thank you all for joining us. And in particular, I want to thank our panelists today who will be speaking to us from different countries in East Africa. Some of them are not with us yet, but they will join soon. I'll make an introduction and hopefully we'll take it from there. First, I want to introduce the Vice Chair of the ADR Committee who has just joined us. Arthur, good afternoon.
Good afternoon. Can you all hear me?
Yes, we can.
Thank you very much.
Mr. Igeria has practiced law for over 30 years in the areas of civil litigation, conveyancing, commercial law, arbitration, and mediation. Besides being a very highly accomplished lawyer, he is highly skilled in ADR mechanisms through the appointment of the former president of Kenya, Mr. Uhuru Kenyatta. He used to chair the Nairobi Center for International Arbitration and has a good track record with the two main ADR mechanisms of arbitration and mediation. And he has a very, very good track record of resolving cases that had lagged in courtrooms for many years. Mr. Igeria graduated from the University of Nairobi, bachelor's degree in 1989, and was admitted as an advocate of the High Court of Kenya from the United States, Business and Finance. He's an accredited mediator by the Chartered Institute of Arbitrators, the Mediation Training Institute of Kenya, the Strathmore Dispute Resolution Center, and the Mediation Accreditation Committee of the High Court of Kenya. He sits on the CIAB Nairobi branch committee. I'll then introduce the panelists. Unfortunately, I won't be able to be with you throughout the webinar. My colleague and vice chair of the committee has kindly agreed to take on the moderating role throughout. But I'll introduce our speakers today from 4 different African countries, East African countries. I'll introduce Dr. Wilfred Mutubwa first, who is the chairman of the Chartered Institute of Arbitrators of Kenya. Wilfred holds a Doctor of Laws degree in International Economic Law, Trade and Investment Dispute Resolution from the University of South Africa. He's a member of the task force appointed by the Chief Justice of the Republic of Kenya on ADR and specifically mandated to roll out court annex mediation and other forms of ADR mechanisms. He is listed on Mauritius International Arbitration Center, the Nairobi Center for International Arbitration, the Kigali International Center for Arbitration, and he has experience in over 60 arbitrations and mediations. He's an arbitrator, mediator, and counsel. In 2017, he was recognized by Arab Africa as one of the top 100 arbitrators in Africa. Welcome, Dr. Mutubwa. Next, I'll introduce Ms. Madeleine Kimmel, who is the secretary, arbitral secretary of and president of the Tanzania Institute of Arbitrators. Madeleine is a practicing commercial and corporate lawyer and the founder and principal director of iResolve, a full-fledged arbitration practice established in 2014. She mainly provides arbitration and ADR consultancies, represents parties in domestic commercial arbitration, and or acts as an arbitrator, commercial mediator, and arbitral secretary in both domestic and international arbitrations under Tiaa, UNICITRAL and other ICC rules and others, and also acts as an arbitral secretary in complex arbitration. She serves on the panel of arbitrators of SADC, NCC, TTIAB, SHIAC, and KAJAK. She's currently the president, Tanzania Institute of Arbitrators, chairperson, Africa Asia Mediation Association, regional director, Center for International ADR Alternative Dispute Resolution, and a member of the ICC International Court of Arbitration. She's a member of the ICC Africa Commission, the ICC Commission on Arbitration and ADR, and a member of the IBA Africa Arbitration Network and SIAC Africa Users Council. She is a fellow of the World Mediation Organization and representative of ADR Point Greece for Tanzania, and in fact is on the ELS committee as well for ADR. Welcome, Madeleine. Next, David, could you check on Dr. Fidel Masengo? He has not joined yet. And I'll introduce Ms. Nora Kagwa, who is the Registrar of the International Center for Arbitration and Mediation in Kampala, Uganda. Nora Kagwa is she is a partner and head of mediation and arbitration at Oasis Advocates, and she is the vice chairperson of the Chartered Institute of Arbitrators, the Ugandan chapter. She is a part-time lecturer at the Uganda Law Development Center as well. Welcome, Nora. So we'll introduce Dr. Masengo, who will speak on behalf of the Kigali International Arbitration Center when he gets here, when he joins the call. So welcome, ladies and gentlemen. For the participants, wherever you're joining us, please feel free to use the Q&A. I see in the chat box, Dr. Masengo says he's on the call, but he's probably joined using the participants link. David, could you assist?
Madam Chair, I'm going to upgrade him to panelist.
Please do, and while you do that, I'll just introduce him as well. Dr. Fidel Masengo is the former Secretary General of the Kigali International Arbitration Center. He served on the first board of directors of KIAC since 2011 to 2000 for 6 years to 2017. He has also served as a deputy chief of Parity and senior technical advisor within USAID Chemonics International Land Project. Dr. Masengo worked as the Director of Public Prosecution Services between 1999 to 2001, and as the Director of the Administration of Justice with the Rwanda Ministry of Justice. He holds a master's degree in economic law from the University of Louvain in Belgium, a PhD in law from the University of Antwerp, a doctorate in theology from Life Pacific University of Canada. He is registered as an advocate of Rwanda since 2006. He has written articles, books, led master thesis in law, including arbitration law. He has attended many arbitration conferences as a key speaker. He has many certificates in arbitration and is a former lecturer of international economic law, international competition law at the Kigali Independent University, and international arbitration law at the Institute of Legal Practice and Development in Rwanda. Welcome, Dr. Masengo. Arthur?
I can hear you. Thanks a lot. I was watching, but I was on the participant list, I think, or webinar. Now I'm on panelists.
Perfect. So I would like to hand over to Mr. Igeria to lead this. I really am appreciative of all the speakers that have come to inform our membership on what your institutes do. And please continue to feel free to use the chat box and the Q&A to ask questions. And I'll be here until I have to leave. Thank you.
Thank you very much, Florida. And without much further ado, I think we will go straight into the business of the day, which is our webinar. And to start us off, I believe you were to give us the welcoming remarks, Florida. And so I'll invite you to do that, then you can kick us off.
Sorry, were you speaking to me, Arthur? I didn't quite catch that.
Sorry, no, I was saying, what I said was, I don't know whether, I came in a little late, so I don't know whether you had done your welcoming remarks, apart from the introductions.
No, I just did the introductions.
Yes,
so
okay.
Feel free to do that.
Yeah, so I according to the program, you were to give the welcoming remarks, but now that you've requested me to do so, I'm happy to do that. So on behalf of the chair and the rest of the members of the ADR committee, I would wish to welcome you all to today's webinar, and thank you for sparing time to attend. I'm looking forward to hearing good things from the panelists, who, as you can see, are seasoned practitioners in the area of alternative dispute resolution in East Africa. I would, going straight into it, like to invite our first speaker, the first panelist, Dr. Wilfred Mutubwa, who is well known to all of you, and me included. He will give us a brief overview on the subject of understanding the role of various arbitral institutions, and then we will flow on from there and develop the conversation. So Dr. Wilfred Mutubwa, I'd like to invite you to take the stage and address us, speak to us. Over to you, Dr. Mutubwa.
Thank you very much, Arthur. Thank you very much, CEO and colleagues. I am excited to be here. I'm happy to be here today. I am particularly excited to speak about arbitration, a subject that is very close to my heart, but within the context of the East Africa region and integration effort. I am happy to see that we are colleagues from across the many jurisdictions that is the East Africa community, right from Kenya to Uganda, Rwanda, Tanzania, Burundi, Congo, South Sudan. And what it tells me is that the future of cross-border dispute resolution is great. And the future is great because notwithstanding the various legal systems which we are accustomed to in our usual practices, we are able to come together because of a common objective that is the East Africa integration effort. And I want to say something a bit about arbitration and institutions in East Africa. Now, the Chartered Institute of Arbitrators, which I have the privilege and honor to lead, at least for the last 1 year, going into the second year, is an organization that landed on the shores of the continent in the year 1984. So we are just 2 years shy of 40 in Kenya, but it's an organization that was established in 1915 and given a royal charter in 1979. So it has a long history. Its forte is in training. 8 out of every 10 arbitrators trained on the globe are trained by the Chartered Institute of Arbitrators and certified as such. I want to say something about the dynamics of arbitration. Now, arbitration on the continent is on the rise. The numbers in our own institute show, and we conducted a survey last year in December, it shows that year on year, there are at least 20% more requests for arbitrators. And at any one point in time, year on year, the Chartered Institute of Arbitrators Kenya has grown its membership averagely by about 20%. I was just looking at the numbers before I came into this webinar. And one of the things that stood out is when we started last year, we had about 700 active members of the Chartered Institute of Arbitrators Kenya branch. Today, as we speak, we are upward of 1,200 members. Just within a short 1 year, we have been able to rise our numbers. Next week, we are excited to go to Uganda, Kampala, where we are. In fact, this week, Friday this week, we are launching the Uganda chapter of the Chartered Institute of Arbitrators. We established the Nigerian branch. We have also helped to establish the Zambian branch. We have also taken our trainings to Malawi and to Tanzania, and we hope very soon that those jurisdictions will have a branch or chapter of the Chartered Institute. So institutional arbitration is, or arbitration through institutions such as the Chartered Institute is on the rise. What we do at the Chartered Institute of Arbitrators is basically do three things. We promote arbitration and other forms of ADR, particularly mediation and conciliation. So we promote, number two, we engage in training. We train people right from the basic level to the very highest level of a chartered arbitrator in the trade of arbitration. We also promote the objectives of ADR in whatever manner, including by speaking and making presentations in conferences such as these, engaging in research, developing rules which are applied in dispute resolution, and many, many other forums where we push the agenda of alternative dispute resolution. Today, when you look at the participation of the Chartered Institute, for instance, in Kenya, in shaping the discussion around ADR, in promoting the use of ADR, we are leaders in our own right. The Chartered Institute of Arbitrators Kenya branch, for instance, accounts for at least of the appointment of arbitrators within Kenya. Any disputes that arise in Kenya which have an arbitration clause, and if you read many of the arbitration agreements which people enter into, commercial people in Kenya, increasingly you will see that the Chartered Institute of Arbitrators is the default appointing authority. It says something about the confidence that people have in the institute, its leadership and its structures, and above all, in the quality of arbitrators that we produce. So, other to speak about the role of institutions, I think the role of arbitral institutions in East Africa should be focused on three areas. Number one is on training. Training so that you can give competent people to the market, people with integrity, persons who will hold themselves out as arbitrators or neutrals of the very highest standard, quality, caliber, and training. So training is critical. The second role of institutions like ours is to maintain registers, to prepare ourselves to have model arbitration clauses, mediation clauses, adjudication clauses, and to be ready to offer to the public, to the private sector, to state and non-state actors, ready-made arbitrators, right from the lowest level to the very experienced in the various fields. We are a membership body, for instance, cutting across very many professions. When I look at my register, I have lawyers, I have quantity surveyors, architects, we have chartered surveyors, we have doctors, we have politicians, we have accountants, we have every manner of people, and some of whom are on this platform. Many of you will acknowledge the fact that when you have an institution whose foundations are competence, are integrity, and consistency in terms of the product they give, it increases the confidence among the users of the product. I always tell my arbitrators that when you sit in your chambers as a practitioner hearing parties, or as a party representative, or as an expert witness trained by the Chartered Institute, you are the face of the institute. You are the face of arbitration. People lose or gain confidence in arbitration, mediation, and adjudication because of the experience they have had with a neutral. And therefore, as you sit in your private chambers, as you sit in your boardroom hearing disputes, you are actually representing a community of 15,000 members of the Chartered Institute spread across the globe. So it becomes important, and it behooves every individual member to rise to the occasion, to always maintain the standards we are known for. The third element is to influence policy. One of the things that I'm usually very excited to speak about is the future of East Africa integration and Africa integration generally in terms of trade and investment. There is a lot of push towards the Africa Continental Free Trade Area. There is the push, there is discussion excitement about the integration of markets, the opening of markets, the free movement of goods and services across the borders. Now, once you start trading beyond the borders, you must get a dispute resolution mechanism that addresses cross-border concerns, a dispute resolution mechanism that is beyond the territorial sovereignty of states. So courts, domestic courts then cede ground to international arbitration in areas when we now speak about international commerce. And this is where arbitration and arbitral institutions such as the Chartered Institute, such as the Nairobi Center, the Kigali International Arbitration Center, and others become key players. My challenge to arbitral institutions in Africa is this. You see, for a long time, arbitral institutions in Africa have been complaining, including arbitrators practicing on the continent, that they are not getting as much work, international references or disputes where they are appointed as neutrals involving African states or even non-African states, and yet Africa contributes a significant number of disputes, particularly investment arbitration and commercial arbitration beyond what happens on the continent. But my challenge has always been this: what are we doing about it from our end? And what we have done, for instance, or started doing as African institutions, is to look inward and say, we will create our own international arbitration space. If we have a dispute involving a Rwandese and a Kenyan supplier or contractor or parties, we then have to look and ask, what experience can we give African arbitrators by appointing each other in disputes which involve intra-Africa trade disputes? But this is not going to happen easily if we operate our institutions as small islands, you know, as Tanzania Institute of Arbitration, Chartered Institute in Kenya, another one in Rwanda. We must find a way in which the platform speaks to our various needs. We must then have some platform, some panel that is pan-African, so to speak, where we speak about disputes and appointment of dispute resolvers within the continent. Again, our institutions, particularly, and I am always fond of referring to the Africa Arbitration Association as the sleeping giant, the organization that can bring all of us together, seek a seat in the African Union discussions on continental free trade area. And this is my argument. I have always said, look, if African arbitrators want to benefit from the integration of markets in Africa through the Africa Continental Free Trade Area, then they must have an observer seat in the AU itself. And this can only be achieved through an umbrella body such as the Africa Arbitration Association, pushing the agenda of arbitration, regional centers being at the center of trade and investment dispute resolution at the continental level, but only if they are able to lobby at that very high level. So I want to challenge the leadership of the AAA to bring us together, take a position within the African Union, and push for dispute resolution within the sub-regions, because we already have established, experienced arbitration centers and arbitrators across the continent. Now, free movement of services. Free movement of services is key. An arbitrator coming from Cote d'Ivoire should be able to freely practice either as a neutral or a party representative or an expert in a tribunal in South Africa. Now, until and unless Africa achieves true movement of services, right of establishment, movement of labor, all we are talking about in terms of international or intra-Africa dispute resolution becomes a myriad. It becomes a myth. It becomes a song that we will sing in conferences and in forums such as this without getting forward. My suggestion to African institutions is that we are now of age. Some of us are going beyond 40 in terms of our lifespan in Africa. We have very solid arbitrators who have sat in very high level disputes across the globe. We have strong mentorship programs. For instance, in the Kenya branch, we run a very strong scholarship and mentorship program where every arbitrator trained by us is assigned to at least 3 arbitrators to sit through, learn the skills, and perfect the art of arbitration before we release them into the market. It is a growing area. When I joined the Chartered Institute about 15 years ago, we were recording about 20 disputes every year. And remember, we are a default appointing authority. This year alone, my projection is that I, as chairman, will have appointed, this year alone, the year 2022, the projection is that we will have appointed at least 300 neutrals. In the next 5 years, we see ourselves appointing over 1,000 neutrals in disputes. And when you look at the numbers tell you a story. And the story is a story of belief and trust in arbitration, the growth in arbitration in the country and in the subcontinent, and the appreciation of arbitration in courts. I was looking at the number of matters where arbitral awards have been set aside by courts. In Kenya, for instance, out of every 100 matters, maybe 1 is referred back to the arbitrator or set aside. So the story is one where the judiciaries are now appreciating that we play a complementary role. The East Africa Court of Justice, today as we speak, all the judges of that court are trained arbitrators, qualified, competent to discharge their obligation as under the treaty, which gives them commercial arbitration jurisdiction. So the institutions are strong, the numbers are growing, the institutions are professionally run. We hope to see the institutions now rise beyond membership activities to now stake a claim, properly speaking, in the international space. What do we do in the future as I wind up? What is the future and how do we deal with the future? Now, the COVID-19 pandemic presented to us a challenge, which was also a blessing in the disguise. What happened is that when the COVID-19 pandemic came, many of the arbitrators practicing on this side of the continent were used to in-person proceedings. They were used to proceedings happening in physical locations. They were used to taking evidence in hard copies. But today, as we speak, unless it is only for purposes of the hearing, and many others actually take the proceedings virtually, you will notice that many arbitrators are now defaulting to proceedings being taken virtually. You will also notice that many of them have invested in platforms, including counsel representing parties have now invested in platforms where documents can be shared and used in arbitrations virtually. We would not be here today if virtual proceedings had not been embraced. We would probably be meeting somewhere in Rwanda or Tanzania in a hotel where we would have taken 3 or 4 days to go there just to discuss this very important topic. The point is this: arbitration is becoming cheaper because the processes around arbitration are becoming virtual, are better managed. We are better managers of time. We are better managers of technology. We are better managers of the process because of the enabling environment that is created by innovations that came as a result of the COVID-19 situation. My parting shot is to say this: I have sat as an arbitrator in proceedings at the real center of commercial disputes in London. I have sat in African arbitral panels in Kigali and other places. I have also sat in domestic arbitration panels here in Kenya. And I can say this: the quality of arbitrators, the quality of arbitration awards that come out of Africa are just as good as any across the world. What we have not done is to perhaps project ourselves in a manner that gives us the leverage to sit as dispute resolvers in disputes beyond our borders. I have seen very many good domestic arbitrators who are content in dealing with disputes within the borders. But I think the future of African arbitration lies in tapping into the continental free trade area, pushing for free movement of labor, free movement of services, the right of professionals to establish offices and to establish practices across the continent, and getting a seat on the African Union and other organizations, including the East Africa Community and other sub-regional bodies. But as a leader of one of the foremost arbitral institutions in Africa, one thing I can vouch for is that the place of arbitration in Africa is safe. The place of institutional training, institutional arbitration, and the place of the African arbitrator is promising going into the future. I will take questions as we go forward, but I wish to cede the floor back to the chairman and my good friend, Mr. Arthur Igeria. But allow me just to recognize the presence of some of our board members of the Chartered Institute. I can see Mr. Paul Ngodho, who has joined us, a foremost international arbitrator in his own right. And of course, the chairman himself, Mr. Arthur Igeria, is one of our directors at the Institute. Thank you very much for the opportunity. Back to you, Chairman.
Thank you very much, Dr. Mutubwa. Thank you for your very incisive presentation. Clearly, you're very well versed with these matters, and I know the attendants are listing their questions in readiness. So I will structure our afternoon engagement so that we have a question and answer session after all the speakers have made their presentations, so that then we're able to flow with ease. And moving on, I wish to invite Madeleine Kimmel, who was introduced to all of you earlier. She's going to be our next speaker. And Madeleine is also very well versed with matters to do with ADR, not just arbitration. And I think that is in fact what forms the basis and backbone of her practice as a lawyer. So Madeleine, over to you, and we look forward to hearing what you have to tell us this afternoon.
Thank you very much, Arthur. Thank you for that kind introduction. And it is always great to hear the proposals and the motions that have been tabled by Dr. Mutumba. Very interesting indeed. Now, for myself, I'll be speaking on institutional arbitration and focusing in the jurisdiction that I practice in. I'm practicing in Tanzania, and the state of affairs here is slightly different from our neighbors, Kenya, Uganda, and the rest of the region. We are currently evolving through the first year and a half of the new arbitration regime. We did have a new enactment that came into force in January 2021. Now, with this new enactment, what I can say is that it had a major impact on the institutions that are currently that were currently in place at that time when it came into force. When it came into force, we had the Tanzania Institute of Arbitrators, where I am sitting as president and serving my second term as of September this year. And we had the National Construction Council, and this was a statutorily formed institution. It is an institution within the statutory body named as the National Construction Council. And so therefore it is not a standalone institution, but it sits inside the National Construction Council. It is a unit, I would say. I think it's best described as a unit. And its mission is to provide for the administration of construction-related disputes and administering arbitrations, adjudications, and mediations in the entire ADR spectrum, as I would assume, including the dispute boards that are usually a creature of the FIDIC contracts and the contracts that come out of that industry. Now, those two were at that time operating without the need of having to be accredited. Now, with the new enactment, there was a system that was introduced, an accreditation system set out coming out of Section 64 of our Civil Procedure Code, requiring the institutions and the neutrals to be accredited. Now, with the regulation that was passed in 2021, that was GN or Government Notice 147, although it had laid out the criteria for the individuals who wanted to be accredited, either as conciliators, mediators, negotiators, or arbitrators, it failed to outline the criteria for what criteria an institution would have to fulfill to be accredited. And so we were charged with the task to make applications earlier on later on in 2021 on how best we can be accredited and the criteria to follow. And so that came as an afterthought. And so the Tanzania Institute of Arbitrators was able to get accredited at the very end of the year. What impact did this have on the institutions? One, we had to halt most of the appointment procedures that we are tasked to do. This is one of the services that the Tanzania Institute of Arbitrators does. That is the appointing, being an appointing authority, either by creature of the clause, the arbitration clause that vests with it that authority, or where the parties have consented to engage the institution as an appointing authority. And so that task halted for a period of about 6 months, so as to allow the institution to be accredited and to be in good standing of that requirement. Now, what comes next from this accreditation system is that there are reporting requirements where, in order to comply with the certificate of accreditation, the institution is now required to render or submit a report to the registrar that sits at the Ministry of Legal Affairs. The report in itself, we do not know the contents thereof, that should be included in that report, because this is our first year of being under this regime. And so what the regulation says is merely saying that there has to be a report of the activities and operations of the institution or the accredited person. And so a report would have to be tendered on the lapse of that year or 2-year term. That is still also unclear. Is it upon the lapse of the validity of the accreditation, or is it on a yearly basis? It is silent. Now, along with the report, if there are any changes within the institution's corporate, maybe governance structure, then that would also have to be reported on a separate point, on a separate note, as a change in particulars of that institution. And so therefore, there are reporting requirements and notification requirements that come about from this new accreditation system. The accreditation system, not only does it accredit domestic institutions, but also accredits foreign institutions, and that criteria is not very clear at this moment in time. At the moment, we can see that there are about 5 institutions that have been accredited. Those institutions, aside from the NCC and Tiaa, include the Tanzania International Arbitration Center, include the Association for Consulting Engineers Assets, and AQRB, which is the Quantity Surveyors Association in the country. Now, that already shows that we are a growing or growing community in Tanzania. There is a multiplication of institutions and associations that are providing for institutional support for arbitrations and the likes. It may be fair to say that the pure breed of institutional structures in the country would be the first two that I've indicated, because what we can see from the other associations is that there are merely maintaining lists or panels of arbitrators or panels of adjudicators, whereby some of their members and those who have opted for them to be as appointing authorities to be able to utilize those lists that have been approved by them. Moving on to my next point, and this really comes from the issue that has been already tabled by Dr. In his address, which is really the freedom of movement of arbitrators. With this kind of accreditation system and imposing these requirements, it's very sensitive to the principle of party autonomy, one. And secondly, it may hinder Tanzania's progress in setting itself as a preferable seat, maybe even within the region and across Africa. And so the accreditation system itself would need to be somehow reviewed in light of these challenges that we have addressed in most of our engagements with the government in terms of lobbying as Tiaa, lobbying for a more transparent accreditation system whereby this particular authority could be let out to the institutions themselves, which usually are the ones who carry out the capacity building exercises, the trainings, and the continuous trainings of their panels. And these institutions are well aware of those persons who are of good standing with those institutions, and those persons who are competent and able and have the competence to administer or to sit as arbitrators, mediators, conciliators, and the negotiation that is also part of the spectrum that has been included in the government notice 147 for accreditation. And so this kind of accreditation system for Tanzania has been welcomed, because we do recognize that this will increase the quality of the service that we aim to offer the end user. However, there needs to be a way to allow for not only the foreign element to freely be able to practice within maybe a seated Tanzanian arbitration, but also for those arbitrators coming in from the neighbors, the East African region, also to be able to practice for purposes of those cross-border claims within the region. Now, along with this presentation, I wanted to also focus in on the need for scaling up human capital in the jurisdiction in scope here, which is Tanzania. Human capital, human capacity building, not only the staffing within the institutions, but also the judiciary, the lawyers, and other stakeholders is crucial to any success story. And so one of the calls that the Tiaa has in charge of is to ensure that trainings are conducted. We do trainings with the Law School of Tanzania. And as you heard here from the chairperson of CIAB, Dr. said that we do also trainings in collaboration with the Chartered Institute of Arbitrators, the Kenyan branch. We collaborate with other institutions such as universities in the country to conduct trainings and capacity building or awareness exercises within Dar es Salaam and other upcountry regions within the country. Now, from an international perspective, Tiaa has approached several organizations that are such as the AAA, which is the Africa Arbitration Academy, to allow Tiaa and its members to have access to an international platform where they can also access further training and further enhancement of their practices. The members are also having access to other institutional support, such as the government wing of the German government wing that provide GIZ, that provide for support in ADR in the country. And so with these initiatives that are being put in place, I think in the near future, we will see more and more growth. When we came in as the governing council that just left in August in 2018, the membership base was at the hundreds and fifties. When we were being re-elected in 2 weeks ago, we had a membership base of 277 members. All these members are keen ADR enthusiasts who would wish to get further access to more and more training from across the globe. Not only that, the opportunity to serve as arbitral secretaries, serve as mentors, if possible, with arbitrators that are carrying on arbitrations that are currently under the administration of Tiaa, and contributing as they can where these opportunities arise. The opportunities that the Tanzania Institute of Arbitrators has at the moment are not only the essay competitions, but also, yes, Arthur, you have your hand raised.
No, my apologies, that was an error. My apologies.
Thank you. The opportunities that are available to members are essay competitions to gain the access for mentorship that I spoke about, articles being called for purposes of publication and having that avenue to showcase their knowledge in arbitration. We, as the institution, having been in place since 1996, and being that we are a member-based institution, it makes it all the while more difficult to seek for the funding support for most of the initiatives that are currently in our strategy. And the strategy is to seek further donor support in order to implement these projects and initiatives that are in our strategy. The strategy includes improving the infrastructure. We're not going brick and mortar because we do realize that innovation and technology has really taken up the space, but we do need the infrastructural support to have access to more state-of-the-art hearing rooms and breakout rooms, and administrators' offices, case managers' offices, and the likes. And so part of that strategy is to get the donor support in order for us to be able to improve on the infrastructure, focusing on the technology, but also on the conventional, traditional infrastructural support that we do offer as a service. Along the lines of funding, there are also initiatives to fund students that are currently undergoing their law degrees. We found that through conversations and exchanges that most of the universities are still focusing, putting less focus on the use of alternative dispute resolution. And so therefore, some of the funding would be utilized to create this awareness within that younger generation so as to have the pool of ADR practitioners that are coming in future being able to be confident in ADR. So there has been a lot of initiatives under the Tanzania Institute of Arbitrators. We have been able to play our part despite the fact that we do have a lot of competition. As I said earlier, there could be about 10 institutions, only 5 having been accredited currently in Tanzania. The Tanzania Arbitration Center, as you may all be aware of, that is a statutory body that was created under the new act. That is currently still not in operation. However, it is an institution that has been established under the Act and could be in operation very soon. The Tanzania International Arbitration Center is also a separate entity, and this entity is pretty new because it was established in 2020, and that is organized through the support of the Tanganyika Law Society. And so it also has its teeth on this community as well. And along with these other players, what Dr. has indicated in terms of working together, collaborating, and setting out goals that we could achieve together, this is something that these associations, along with the other associations that I represent, is looking to perform. One is that we have realized there are a multiplication of institutional administering institutions in Tanzania. And so we're looking at the prospects to consider maybe a one single center approach. And this is really going to level up that independence and create a more impartial environment. And so letting go of those institutions that are affiliated with the government and merging maybe the current institutions into that single body that could bring much more weight in this community. Creating that entity will take time, will take negotiations and sitting and agreeing maybe in unison what would be best suited for the current state of play in Tanzania. And so that would be all, Arthur, on my part, and the situation at hand and the state of affairs of institutions in Tanzania. Thank you.
Thank you very, very much, Madeleine. Apologies for that error, and but thank you for your excellent presentation. I believe we are all now a lot better informed about the institutional situation in Tanzania. And thank you so much. Please don't leave us, because I know there are going to be many questions that people will be raising. They want to hear more from you. But moving on, allow me now to invite Dr. Masengo to talk to us about the situation in his country, Rwanda, and to give us his insights also on the topic at hand. Dr. Fidel Masengo, my good friend, the stage is yours.
Thanks a lot, Chair Geria. Good afternoon to everyone. And I'm very happy to see you again. I think we've seen each other before COVID. It is time for you to move to Rwanda.
Yeah, Dr. Masengo, if you could adjust your camera slightly so that we can see your full face. We're only
Do you
seeing
see me
half
now?
the face. Exactly, excellent.
Now you see me?
Yes, now
Thanks
we
a lot.
see you.
Yeah.
Yeah.
I was
Thank you
saying
very
that we've seen each other long before COVID. It is time for you to come to Rwanda and see us. We have a conference next week at Tiaa.
Thank you.
Yeah, thanks a lot. Let me just greet everyone and commend also the presentation that were conducted by my predecessors, and I really learned a lot about what they are sharing. Of course, I'm going to talk about the institutional aspect in Rwanda, but also before just focusing on Rwanda, I want just to give some, a brief introduction about the whole region in few words. As international investment and trade on the African continent is growing, the number and the frequency of commercial and investment disputes in Africa have inevitably increased. If you consider only in these recent years, the number of commercial arbitration cases involving African parties has even grown, I can say, exponentially. However, despite that growth, African-related disputes have kept lawyers busy for a number of years in traditional arbitration institutions such as International Chamber of Commerce, ICC, and the London Court of International Arbitration, RCA. In 2019 only, the ICC itself had 130 cases involving sub-Saharan African parties, accounted for an average of 5% of all parties in its 2019 caseload. And the 2019 caseload for the London Court of International Arbitration shows that African parties were involved in slightly more than 10% of their cases. Like commercial arbitration, investment arbitration cases involving also African states, especially those who are respondent, have also seen a very significant increase in recent years. According to the most recent statistics published by the International Center on the Settlement of Investment Dispute at ICSID, African states are today party to almost 22% of pending arbitration. Given the dynamic growth of African economies and the expansion of cross-border trade and commerce, we can also notice this in East African community. The need for readily accessible African arbitral institution has become increasingly urgent. As a result, today, nearly 100 arbitral institutions are established in Africa. Some countries have multiple arbitration center. It was even said by my colleagues in their presentations. Of course, not all of those institutions will earn strong global or even regional reputations, because when you see the survey that was conducted by the School of Oriental and African Studies, SOAS, in 2020, their report, they said that there is a list of top 5 arbitral institutions in Africa that are full operational with important caseload. And Kigali International Arbitration Center is fortunately included in that list. In fact, within the past years, Rwanda government and Rwanda Private Sector Federation have realized that arbitration is gradually becoming an indispensable condition for the development of African economies, as Rwanda works towards transforming rapidly into a knowledge-based economy, attracting more investment. The country's steps taken to improve doing business recommended having an international arbitration institution, crucial in not only helping in resolving commercial disputes through the use of arbitration and alternative dispute resolution, and as a way of increasing investment confidence. The creation of the Kigali International Arbitration Center in 2012, 10 years ago now, has contributed access to justice in commercial justice and has reduced, of course, the backlog of cases in the courts. Now, let me just give you a brief summary on its achievement. Since its establishment, Kigali International Arbitration Center has set out its bold ambition to become the reference point for international dispute resolution, not only in the region, but also for the entire African continent. KIAT's ambition to entrench itself as a regional and international arbitration hub is further illustrated by the decision that was taken since its establishment to appoint foreign board members. In fact, 3 out of 7 of its board members are not from Rwanda. They are foreigners, some from Europe, others from the African continent. In order to strengthen the center's independence, credibility, and its regional and international influence, those board members are actively involved in the management of the center. So this means that the center is really independent and has board members with strong reputation. Kigali International Arbitration Center has also recruited world-class arbitrators with extensive experience to be on its panel of arbitrators who are in a position to offer the international business community to arbitrating in Paris, of course, also in London. It has now more than 150 arbitrators. When you see those arbitrators, they are coming from all continents, and many of them are world-class arbitrators. And in order to be on a panel of Kigali International Arbitration International Panel, you have to be the minimum, at least a fellow of the Chartered Institute of Arbitrators of UK. So this is a very high standard requirement for those arbitrators. Speaking for KIAC's, the reason of creating the center, of course, they were based on economic reasons and also practical reasons. Let me just give some of the reasons. In Rwanda, as well as in many parts of Africa, the issue of costs has been mentioned for arbitration conducted under the aegis of Western institutions. Local client and counsel repeatedly stress on the cost of arbitration proceedings under the aegis of Western institution. For instance, the ICC filing fee is currently $5,000 regardless of the amount in dispute, and its administrative costs can go up to $150,000 in order to address the issue of cost, Paris have an option to choose African arbitration institutions such as KIAC. When they come at KIAC, the filing fee is $250, which is 5% less than the fee charged by ICC. And also the maximum of administrative cost can not exceed 23,000. You understand that it's also less than 7% of what is done at ICC. By choosing to file a case at KIAC, local and regional economic operators, especially those from East Africa, save also transport fees and very expensive Western hotels costs compared to hotels in the region, especially in Rwanda. Second, KIAC, as well as a functioning arbitral institution, has been generating some economic gains, and especially in the region, because many people that are coming can also use our hotel facilities and our local flights. So you understand that it's also a benefit for the East African region in general. I don't want to go in details in this, but there are many other economic related activities for the whole region. To be mentioned, for a few of them, we not only administer cases, we also allow people to use our hearing rooms. We promote local hotels. We also, of course, give a workload to local law firms, and there are also some services such as court reporter services and many others. What's said here for KIAC is also, of course, said for other arbitral institutions in the region that are functioning now. Let me just give you the summary of KIAC caseload. I want to share a screen, but let me say that since 2012 up to now, KIAC has had 199 cases. 199 cases to me is second. I don't know if I'm allowed to share the screen. Am I allowed to share the screen?
Yes, you are, Dr. Masengo.
I'm trying to do so and see if it works. Yes, okay. So I was saying that we've had 199 cases. The statistic you can see there are from July 2012, its beginning, to June 2021. But we have also 22 cases for July 2021 up to June 2022. So total is 199 cases. To me, this speaks volume for an institution that is positioning itself in the region. When you see also here case by market industry, you will see that services, construction and engineering, as well as shareholding agreement and supply of good, some of the sectors where you have many arbitration cases. And this is a good move, and especially speaks a lot for our community. When you see the geographic origin of the cases, the number I'm giving there is just for 2019, 2020, we had 67% domestic and 33% international or foreign cases. When you go to category of cases for 2022, I mean this year, it started with July 2021 up to June 2022, you will see that we have 6 international cases and 16 domestic cases. And for those who have been in arbitration sector, you understand that registering 60 international cases in a short period like this, and during this pandemic season of COVID, it's really a great milestone. On languages of arbitration, I want just to give you the statistic for this year. I'm saying the financial year 2021 and 2022. You will see that we've had 8 cases in English and 4 cases in Kinyarwanda. You understand that even if cases are domestic, we use Kinyarwanda. Compared to what is being done in our courts, it's a revolution, because in many of our courts, Kinyarwanda is the most used language. When you go to gender of arbitrators, I also shared with you the statistic for only this year. Of course, the number is not really good. We have only 4 female arbitrators, while we have 14 male. But it's not about the center, it's about the parties who appoint. But we have a very good number of arbitrators, you know, from other, I can say, gender, especially female. I just want also to say something on the list of international parties. I can't mention all countries, but countries such as Burundi, China, Ethiopia, Egypt, France, India, Italy, Kenya, Korea, Pakistan, South Africa, South Korea, Singapore, the list is very long, have been parties to our arbitration in Tiaa. I just also want to share something on capacity building. When the center started in 2012, we didn't have any trained arbitrator in Rwanda. But since that period up to now, Tiaa has trained more than 500 practitioners in arbitration. And many of those that have been trained, I can say that 99% were trained by the Chartered Institute of Arbitrators. And we have a good number of fellows of the Chartered Institute of Arbitrators. And you did not mention this. We have now also the Chartered Institute Arbitrators branch in Rwanda. So this means that the work of training arbitrators will really grow with the branch, but also the center has been partnering with the CIAB to train arbitrators. We didn't only train arbitrators. The good thing, we've also trained judges. All our judges in commercial courts have been trained in arbitration. Many of them are like members of the Chartered Institute of Arbitrators or associate members. And none of the cases that have been submitted to court for challenge, none of them has been set aside since the beginning up to now. So you understand that we have also a friendly judicial system that supports arbitration. I think what I can say about the center is that, but also I just want also to add that we've been conducting conferences. I can't name all the conferences, but only for the last 4 years, we have had conferences by the SOAS. We've had conference by the East African International Arbitration Center. We've had, also we are planning to have also a conference by Tiaa next week, where we'll be celebrating 10 years of the existence of the center. And we also attend many conferences as a center, just to promote the center. And that even currently the SG of Tiaa is not available because he's in London for another big event. So you understand that we do market the center, but I can say that the right way of marketing a center is not only having conference, it's also by cases, because when you have cases and you have people who just attend conferences, they speak about the caseload about the center, they also share about the experience, they know how the institution works, especially the speed in processing cases, the appointment, the independence. All those are, advocacy tools that have promoted the center to the level where we are. So I can't be detailed more than that. I'm willing to just come in with the questions from the participant. But the center is doing very well, and I do invite everyone to recommend the center to any future disputant. Thanks a lot for your good attention.
Thank you very much, Dr. Masengo, for your very detailed presentation. I'm sure the participants have learned a number of new things about the situation in Rwanda, and I know there'll be questions flowing in due course very, very shortly. So please stay with us for a few minutes as we wind up today's session with the representative from the registrar of the International Center for Arbitration and Mediation in Kampala, Nora Kagwa, who I believe is present with us. And Nora, over to you. You were introduced earlier, so I won't go into details of the introduction, but it's good to have you with us. And you have the honor of giving us a grand finale on today's presentations.
Thank you so
over
much.
to you, Nora.
Thank you so much. There's no pressure on me whatsoever, just to wind it up. I'm actually fortunate to have come before my colleagues. They've done a great job emphasizing how much East Africa has come in terms of arbitration. As far as Uganda is concerned, though, which is where I practice and my home, we currently have 4 institutions. We have Praxis, we have CADA, we have ICAMEC, and as Friday this week, we shall have the Chartered Institute of Arbitrators, the Ugandan chapter, which we're very excited about. So the state of affairs, as far as institutional arbitration is concerned in Uganda, allow me to specifically speak about ICAMEC because that's where I work, and I I can speak ably on behalf of ICAMEC and not so much the other institutions. So as far as case backlog is concerned, sorry, not case backlog, but the caseload. I was actually very interested in hearing that Kigali has had 109, if not 199, 196. ICAMEC, which only opened for business in 2019, sorry, has had the great fortune of having 54 arbitration cases. Which speaks to the fact that there's a growing need for arbitral institutions in Uganda. And that's just ICAMEC. I'm sure the other centers, KEDA and Praxis, would also have significant numbers that they would share. So it shows that Uganda actually has a need for alternative dispute resolution, and that people are fortunately enough starting to embrace it. As a center, we've had to do a lot of mindset change to encourage people to embrace ADR, whether it's adjudication, conciliation, mediation, and arbitration. It's been an interesting journey getting to the caseload that we have. But I'm happy to report that we as a center have received great support from the judiciary, from the financial sector, from Uganda Manufacturers Institution, from different professional bodies, which have all partnered with us on different activities. As a center, we work with not only parties who want their disputes administered by us, but we also engage different professional bodies. We engage NGOs. We do mediation trainings for NGOs. We do tailored trainings for the banking sector. We are actually planning to have a training that's going to educate the banking sector on which of their disputes can be arbitrated and how best to conduct their arbitrations. So one of our mandates as a center has been to do a lot of capacity building so that we can promote ADR and the growth of arbitration in Uganda. So one of the things we do is trainings. We have, since 2019, we have trained 187 neutrals. That's in construction claims, arbitration, mediation, and so on. So currently, what we do is we partner with institutions like CIAB. I'm very happy that the chairman is also one of the panelists. We partnered with CIAB first in 2019, and the partnership saw 16 Ugandans get accredited by CIAB. Currently, we're also partnering with the CIAB, the Ugandan chapter, to see about well, hopefully after the assessment, we'll have about 25 to 27 arbitrators accredited. So we value partnerships, and we know that if we engage with our colleagues in the profession, that we'll be able to transform arbitration in Uganda and across the region. So as far as the center's procedure rules are concerned, we have learned from COVID. We embraced virtual arbitration and online arbitration. We encourage the parties to explore these means of arbitration so that it's more cost effective, because we do understand that the economy as it is presents a bit of a challenge to the parties involved in arbitration. So we encourage the arbitrators and the parties to consider virtual arbitrations and online arbitrations for a more efficient arbitration process, and also to reduce on costs. Cost is a very important aspect when it comes to arbitration. Arbitration has been criticized for becoming quite costly. So we have encouraged the parties to think of embracing technology to make it more efficient. Our rules also provide for emergency arbitration, fast track arbitration. Our goal is to put in place rules and procedures that cater to the needs of our users. we have a broad roster of neutrals, and the neutrals that we have showcase the fact that Uganda as a country has able and capable neutrals who can determine disputes. We try as much as possible to showcase local and regional talent because we know it falls on us as an institution to put forward our neutrals. So we try as much as possible to front our neutrals and our experts so that they get work, one, but also to showcase the fact that Africa and Uganda as a region is ready to take on disputes of a great nature. Our neutrals also include non-legal experts. We have encouraged professionals, architects, engineers, accountants to join our panel of arbitrators, and we have panels from different professional bodies, and we're constantly engaging with different professional bodies to make sure that we have a good number of neutrals from a wide sector of professionals to come join us so that when we receive disputes, we can give our parties a broad range of variety in terms of neutrals. We are also we have reviewed our pricing fees to reflect the current economic constraints. So our team has come up with an attractive pricing strategy, which should help promote arbitration, because we do understand that, because of the economy and the inflation that we're currently facing, if we don't find solutions, then we are not holding the flexibility that arbitration comes with as an institution. So we have reviewed our pricing strategies, and I think ICAMEC is one of the cheapest in the region in terms of pricing, not because we have a better system, but because we understand the economy and we are finding ways to work with the parties. For example, encouraging that parties adopt a hybrid arbitration, which is virtual and physical, so that they don't have to spend as much in terms of expenses. So we're trying to look at ways in which we can save costs and make arbitration more attractive as an institution and as a country. Uganda has 2 appointing authorities. So where parties fail to appoint, they have 2 reference points. That's ICAMEC and KEDA. And parties have the freedom to go to either to have their neutrals appointed. The center is also working with different agencies to influence policy change, but also engaging with the judiciary to ensure that once the awards are published, then they are enforced. We're currently engaging the judiciary in the bid to train our judges, as other jurisdictions have done. We're taking a leaf from Kigali, which has trained a good number of its judicial team, so that they appreciate arbitration. We've also, of all the disputes that have been referred to our center, none of them have been set aside. Applications have been made for them to be set aside, but the awards have been upheld. For the last about 3 years, as a country, we have witnessed a judiciary that is pro-arbitration, which we welcome as a profession. The judges in Uganda seem to appreciate arbitration and the principles on which it is based, and we have seen their rulings and their judgments reflect that. So we are happy to report that Uganda is embracing ADR, and we're happy that the judiciary is supporting it. And we hope to also offer them training so that they are better equipped to deal with the different matters that are presented to them. I think that's all I can say. I see also time is not our friend. That is all I can say in terms of Uganda. Thank you so much for the opportunity.
Thank you very much, Nora. And thank you once again for sparing the time, for giving us such a detailed presentation on the situation in your country. And now we will go into the question and answer session. Our panelists are all here and ready to answer the questions. I will deal with the ones that are on the chat posted and start off with our first presenter, who was Dr. Mutubwa. Dr. Mutubwa, if you're present, there's a question regarding whether the questioner asks, is it a case of quantity rather than quality in Africa? For example, what if in East Africa we had 6 CIR branches or 54 CIR branches in Africa? Shouldn't we be concentrating more with enhancing skills rather than opening more branches? And then the next question to you, Dr. Mutubwa, if you can combine both of them, is how do you see the sustainability of ADR institutions in the region vis-a-vis the insecurities of countries? So Dr. Mutubwa, perhaps you could answer those two as we then prepare for the other questions.
Thank you very much, Arthur. I want to take as many. I will combine as many as I can from the.
Okay, that's fine. If you can see them,
so that I can.
The ones that are addressed to you,
so that I can give my colleagues an opportunity to also deal with the others. Thank you very much for the questions. The question of quality versus quantity. It's important to have quality and quantity. Quality is not useful if it's not reaching the right places. Quantity is not useful if it is not of the right quality. So important that we have quality and quantity in equal measure. But again, there is absolutely no problem in having as many variety of institutions offering ADR services across the continent. What I think is important is for us to assure each other that each of these institutions speak to a certain standard, speak to a certain qualification, and they speak to a certain objective. It doesn't matter whether you put the Tanzania Institute of Arbitrators or the Nigerian Lagos Court of International Arbitration or the ICAMEC in Uganda. I am certain that if you choose any of those institutions, the quality of output, the persons who man those institutions gives you the assurance that you are going for quality in any event. So I don't have a problem with that. What I meant is to say, look, as Africans, we must have a point of convergence if we are going to push our agenda. There is always a voice in numbers. And when you're on the table in an organized way, you are likely to be heard. Now, we are not advocating to have 54 branches of the Institute across Africa, but branches are just that. They are branches. We all belong to the same family, to the same community of arbitrators under the same organization that is a chartered institute. Branches make it easier for people to manage their affairs domestically. There are certain matters which must be managed within the territory and it becomes useful. So I do not see a problem with quality. By the way, the question asked whether we should be building capacity. Last I checked, in Kenya alone, we have trained over 3,000 people in arbitration. Across the continent, the Chartered Institute alone, the Kenya branch, has perhaps trained more than 4,000 or 5,000 people. And in the entire globe, we have 15,000 people trained under the aegis of the Chartered Institute, going to 17,000 when I last checked last month. So the point is this: we already have people with immense capabilities, with qualities. My friend Fidel has told you that on the KIAC panel, you already have over 150 internationally acclaimed arbitrators on that panel. So Africa does not suffer the question or the problem of quality. It suffers the problem of organizing the quality and the quantity in a way in which we can all benefit from this arbitration cake. Somebody asked, what is the sustainability of ADR institutions? Now, sustainability is always at the back of my, every day when I wake up, my worry for the Chartered Institute of Arbitrators Kenya has always been sustainability. How do we sustain our programs? How do we give programs that can sustain? One of the ways we are doing that is to give cost-effective training to young people, mentorship, creating the next generation of dispute resolvers. making the courses and trainings and qualifications affordable to the majority of people, young people from college and early professionals up to 5 years. So we have a special program for these people. It is our key area of focus. But sustainability has also something to do with finances. My sister Madeleine has told you how to run an institution sometimes requires a lot of goodwill from members. We at the Kenya Chartered Institute of Arbitrators Kenya branch, believe me on you, we do not collect a subscription, but we have programs, we have platforms, we have events, we have trainings which sustain our operations. If you look at our last reports, the financial reports for the last 3 years, our revenues have grown. They have grown year on year up to 1,000%. We are now able to sustain our programs. We have moved into a state-of-the-art office space. We are finishing we have bought office space. We have put together arbitration facilities for our members, also as part of our sustainability program, so that we have revenue streams coming in through our investments. We are also giving people opportunities and facilities to conduct their arbitrations, mediations, and adjudication. So sustainability is at the heart of African institutions. If we were not running a sustainable institution, we would not be here 38 years later. We hope to go into the future with a sustainable model of keeping our costs low and making sure that we are able to run events and activities that add value to our members, but also sustain our programs and our secretariat. Somebody is asking, there's yet another question. Where can they train? We have an accelerated members training to member level starting in Uganda later this week. If you are really interested, you can register, join the class. We have courses and trainings virtually and in person, literally every week or 2 weeks. So when you go to our website, you will see the Chartered Institute activities for the year and the training. We train mediators, adjudicators, arbitrators from the very basic to the highest level, as I said, up to the fellowship level. I know next month we start an accelerated route to fellows for those who are experienced in arbitration and in the legal practice for over 10 years. You're welcome. So we can have that discussion on the side. How institutions from various jurisdictions can cooperate. You see, today, this afternoon, we have dispute resolvers from Kenya, from Uganda, from Rwanda, from Tanzania, all speaking the same language. Now, the language of arbitration is the language that is universal. It's a universal language. You do not have to come from a certain legal background or from a certain legal family to understand. They are called cross-cutting principles. Principles of arbitrability, severability, finality are principles of international law. So arbitration really is a cross-border dispute settlement system in its own right. So you don't need to speak in Swahili or French or English to understand arbitration. So arbitration is universal. And because of the universality of arbitration, the beauty is an arbitrator from Kenya can sit with an arbitrator from Rwanda, which basically has a civil law approach to dispute resolution, and sit with somebody from another jurisdiction, whether it is Roman Dutch or common law, and still reach a solution to disputes between 2 or 3 people. Now remember, when commercial people meet, they don't ask which legal family you come from before we do business. You will buy a car from the French-speaking country and have a dispute with that person without necessarily knowing that the dispute eventually has to be resolved in one way or another. Shortcomings of institutional arbitration. Somebody says there is bureaucracy. I would have loved to know a bit more of that. What I know for a fact is that when you write to us and you seek to appoint an arbitrator, we will look at the arbitration clause to determine whether the matter is ripe for arbitration, what the clause says about the appointment, whether you have dealt with any pre-arbitration requirements, and we will make an appointment or come back to you on our position within 7 days of receiving your request. There are no bureaucracies. It is just as simple and straightforward as possible. We only charge you 20,000 shillings, the equivalent of $20. Mr. Masengo spoke of $250,000. For us, we are talking about $20 to make an appointment. It does not get any cheaper. It is, yes, $20, 20,000 shillings. Yeah. So $200 actually, $200, $200, 20,000 shillings, you get an appointment. Our arbitrators charge you between 5,000 Kenya shillings and 30,000 Kenya shillings, 30,000 Kenya shillings, $300, nowhere near the $500 that arbitrators elsewhere charge. So it's fairly accommodative here. So I think I've answered many of the questions which were directed to me.
Just one last one, Dr. Mutubwa.
Yes, please.
Someone's requesting you to comment on gender in terms of the numbers of the trained arbitrators in the East African community.
Okay, now I may not have the numbers for the entire East African community. It will mean that we have to take from the different institutions. But what I can say as a microcosm, when we take a sample of Kenya, and when I look at my membership, of course, I join my colleagues in saying the number of ladies is less than that of men, almost on a 70 to 30%. When we look at the highest level of membership, which is the chartered arbitrator level, we have 30 chartered arbitrators in Kenya. I think we now have only 4 ladies, so less than about 10% or less are women. We have made every effort to try and give our ladies the prominence, the encouragement they require. But again, we want to encourage the ladies to also stand up, to step up. When I look at Tanzania, usually the face of arbitration and ADR in Tanzania is Madeleine, and she's a lady and she has stepped up. So it is not necessarily because there are any impediments, but generally in societies like ours, ladies or women tend to play catch up because of many other factors surrounding the community. But the point is this: we have a very active women in ADR caucus group, which looks out for women's interests and women's issues. What we have done as an institute is in every of our programs, our trainings, our conferences, our activities, we always make sure that at least 1/3 of the conference, the panels, the organization or the speakers, the appointments we make, sometimes we make appointments to boards of directors, we give our women at least 1/3 of the opportunities, so that 1/3 of the opportunities will always go to the women members of the institute. Thank you very much. Back to you, Chairman.
Thank you, Dr. Mutubwa. Perhaps I could ask Madeleine, there's a question that has been asked, which is, could we hear from both of you, that's Dr. Mutubwa and Madeleine, and since Dr. Mutubwa has spoken on the issue, perhaps maybe Madeleine, you could add on to this, on the issue of ensuring gender parity when appointing arbitrators in these arbitral institutions. Madeleine, what would be your comment on this or in response to this question?
Thank you, Arthur. And Doctor has pretty much captured it. The numbers at the Tanzania Institute of Arbitrators, for example, I did speak of us having 277 members. Out of those only 74 are women. And on the panel of arbitrators, sadly enough, only 3 are members of the panel of arbitrators under the Institute. And so it is a pretty gray picture to paint. There are several initiatives that we have been embarking on as an institution, including just about a few weeks back, entering an MOU, a memorandum of understanding with the Tanganyika Women Lawyers Association, so that we can start that sensitization within the legal fraternity first, and then of course the associations which are similar within Tanzania, industry associations and business councils, to approach women to ensure that they are aware of these mechanisms, they buy into these mechanisms, and they play a part in building this particular community for female arbitrators and female ADR practitioners. Another challenge we're facing with regards to diversity is that there's a lot of concentration within the cities and no practice out of the city. The focus is on Dar es Salaam, and we're seeing that programs have been crafted using maybe the legal services facility here to now start training paralegals. We do have a legal aid program under the LSF that trains paralegals, and that is one way of approaching these distinct categories. I saw a question with regards to land disputes, and I think, you know, with community-based disputes such as these, we find that programs such as these, which are run by legal services facilities and organizations alike, NGOs similar to that, are much more, you know, at a better position to reach out to maybe the women, focusing on the women and how they could equip them with ADR skills and techniques to allow them to solve land-related disputes within their communities and similar work. But land-based disputes in Tanzania, there is tribunals specific for the land disputes. What you find maybe in an arbitration that would be administered by the institute is probably a dispute arising from a tenancy agreement that has an arbitration clause that has Tiaa as the institution of choice. Now, I also heard from the remarks from Dr. and I'll move on from the gender question towards the question on the kind of requests of arbitration that we get, and the fact that most of our arbitrations, for example, the data under Tiaa for 2021-2022, we received 21 requests for arbitration, and only 7 were arbitrations which included a clause that would trigger us to have mandates to proceed with that. And so on evaluating and analyzing these requests, we find that still we need to build capacity within the legal fraternity, because if we have this general understanding of what an arbitration and submission clause looks like, then we will go away from having requests that are not institutional arbitration clause. They're merely ad hoc, and lawyers understanding that, okay, the right avenue is proceeding on ad hoc and not submitting to the institution and having it, you know, a tryout. So we avoiding that tryout. A lot more capacity building will need to be implemented by the institute, by its partners and stakeholders, including the Chartered Institute of Arbitrators being one of our partners. Thank you.
I think there's a question that zeroed in specifically on your presentation from a lady called Irene, and she asked, what does the Tiaa do to assist newly accredited arbitrators in Tanzania? I don't know whether you had touched on this in some of the questions you were answering, but perhaps you could maybe elaborate on this in an effort to respond to this question.
Mm-hmm. Thank you, Lillian, for that question. I think that's a very credible question, very good question indeed. What the Tanzania Institute of Arbitrators does for new members or newcomers into the institution is really have them to have access to further development of their techniques, further training, give them access to having the mentorship programs that I spoke about earlier, and give them access to draw as within each choice that they have opted for, building, whether they are aiming to be mediators, arbitrators, or all of those positions. So along with these trainings that come along with having to be either an associate, a member, or fellow, there are criteria to meet for you to be on the panel of arbitrators, and that includes the number of years you've been a member of the institution. And so this encourages members to continue to be members, to continue to enhance their skills through these programs that we have, and play a part in the institution. Having access to the council's committees is one of those platforms where one can play a part and give back to the institution in terms of its strategy and implementing its strategy. And so we have different committees, including the Young Members Committee, which is a very new committee established earlier this year. And so that gives them their opportunity, the members' opportunity to learn as they grow within the institution, to then be able to fit the criteria that are set for one to be on the panel of arbitrators. Now, we don't only maintain a panel of arbitrators, but also maintain a panel of mediators and adjudicators. And these different panels all have criteria that have been set out for one to fulfill. Number of years of membership, the number of cases maybe you've been present in as either as counsel, representative, and so on. One of those criteria also includes your commitment to the further learning programs that are conducted by the Institute. I hope that answers Lillian's question. Thank you.
Thank you, Madeleine. Dr. Masengo, please allow me to request you to respond to a question that has been asked here. And the gentleman asks, arbitration is still too expensive for litigants. Why is this procedure expensive when arbitrators can even go to professional judges? I'm not sure I'm reading it correctly, but perhaps you could attempt to answer this question. I think the person is concerned about the cost of arbitration to litigants, and he wants to know why this is the case.
Thanks a lot, Igeria. I may also have some comments on some of the questions that have been also answered by colleagues, just giving the Rwandan perspective.
Feel free to comment.
On that question of the fact that arbitration is expensive. Of course, it said that arbitration is expensive. When I say that, it all depends on the angle on which you see the matter. Let me just be specific. When you consider the costs in filing a claim, when you consider the administrative costs, of course you can say that it's too expensive. But too expensive compared to what? You have to see that, that in two ways. Number one, compare arbitration in East Africa and arbitration outside Africa, because there are people who will not go to our courts. Even if we want them to come to our courts, they will not come to our courts. So if they are investors and they can't come to our courts, then we have to understand that arbitration is an alternative. Now, if we have arbitration in East Africa, it's cheaper compared to what is being done elsewhere in the world, especially the ICC and RCA arbitration. I can't give details. I've already given the details. When you consider the flights, you consider the hotels, the arbitration, procedures fees, the costs of lawyers, all those speaks for our arbitration institution in East Africa. But also when you compare our arbitration to courts, you have also to know that sometimes you think that court is cheaper, but see the length of the procedures. Fortunately, in Rwanda, we don't have cases that take long, especially in commercial dispute. We are ranked number 2 in doing business in all Africa, in all Africa after Mauritius. When you see on enforcement of contracts, we see that many of our cases take less than 5 months to be processed and completed in commercial courts. This means that it's not very expensive in Rwanda to go to court, but in some countries, when you include appeals, you include the time that takes. If a case can, be in the court for 4 or 5 years, you understand that the costs you are avoiding, you end up paying more than what could be paid at arbitration level. So I just want to say that it's all depending on the countries and the matters as well. But you have also to know that there are rules that have flexible procedures. Let me just mention 2. Emergency arbitrators, this is very quick. That one reduces the cost. There is also the possibility, especially our Tiaa rules have a provision on emergency arbitrator. There are rules that have what we call fast track procedures. Those also are the ways of like reducing the cost. Rwanda has adopted now a new ADR policy. It has been adopted like last week, and we still have to implement it. But when you see how it is and the content with multi-tiers procedures, I can ensure that it will be even cheaper to go into arbitration than going to courts, because our policy is really well designed to make sure that arbitration is also cost effective. Yeah, let me just also respond to other questions like 2 or 3. Arbitration association in East Africa. Somebody asked, is Irene, is there any arbitration association in East Africa? Not yet. We don't have an arbitration association in East Africa, but we have an arbitration association in Africa, which is called African Arbitration Association. The African Arbitration Association was established in 2018, and it has its headquarters in Kigali, and it has already conducted its annual conference. The first one was conducted in Kigali in 2019, and we are planning to have another conference in Ghana this coming November. The good things, it has 15 board members who are arbitrators from all of Africa. The chair of the president of the association is from Nigeria, the former Attorney General of Nigeria. But you have 3 members of that association, board members who are from East Africa. Myself, Terry from Rwanda, Njeri Kariuki from Kenya. And the good thing, the general secretary of the association, who is the managing director of the association, is from Tanzania, Dr. Rukia Baruti. She has been managing the association for the last 3 years. So you understand that the association is there, and I do suggest that many arbitrators in our region try to become members of the association. It's really growing as an institution. There is also another question, that why do accredited arbitrators take too long to be appointed and allocated cases? I want to respond this from a center that has been operating since 2012 up to now, and that has many cases, including international cases. Actually, it's not the center that's appointed normally. Normally, the appointment comes from Paris. And Paris based the appointment on several criteria, including the qualification of the arbitrators, including the language they speak. Like actually in Rwanda, we have that benefit of having arbitrators who can use both English and French. But there are cases whereby you have like some arbitrators have been appointed several times, more than like 5, 7 times. And there are cases where many arbitrators have been there on our panel without having an appointment. So it's all depending with the qualification, but remember also in law what we call autonomy of, parties' wills. So if they want to appoint an arbitrator, you can't say that only appoint from my panel. That's another question whereby I want also to just intervene. The last one, I think somebody asked, he didn't put, or she didn't put the name, that is there any internal appeal mechanism as to the merit of the case in case a party is not satisfied with the arbitral award? Please. If somebody is not satisfied with the internal the arbitral award, I don't know any arbitral institution that has that internal mechanism. Rwanda legislation is based on ancestral model law, and our rules also are based on ancestral model rules, and they don't accommodate that things. And I don't think it's a good thing, because this will be a delay to the arbitral proceedings. Rather, we have that the mechanism of going to court for challenge. Article 47, 48 of our legislation of 2008 gives that room to parties to go to court when they are not satisfied, rather than having another internal mechanism, which is not possible. Lastly, that's my last intervention. Somebody asked if cases on land can also be submitted to arbitration. In our context, to ADR. So to ADR, yes, our current policy allows land dispute to be, processed under mediation. And I know many other countries also for mediation is possible, but for full arbitration, many of the land disputes are not arbitrable. Yeah, that's what I can say for now. If somebody, yes, KIAC also is doing trainings, and there is a training that is going on next. It has started last week. The registration has been closed. People have been handed the material. They are starting next week for the Tiaa membership. But if the person wants to do a training, he can choose to go at the center in Nairobi, or also right at the center in Kigali, and we have training. I'm just responding to Victor Mukasa. What if we have trainings in Rwanda? Yes, we do, and he can be informed for the next incoming training. Thanks a lot. That's what I can say. All our training are of higher standards, because they are all conducted by the Chartered Institute of Arbitrators, which is for now the leading institution in training arbitrators around the world. Yeah.
Thank you very, very much, Dr. Masengo. And finally, I will allow Nora to take on one question, which I think will be our last question, as we have more or less run out of time. Nora, there's a question that was asked right at the tail end, which is, can courts review or annul arbitral awards? If yes, on what grounds in general terms? You may answer this question, and you may also add to your comments to the comments that have been made by the panelists, and anything else that you wish to add. Over to you.
All right, thank you. Thank you so much. As far as Uganda is concerned, the Arbitration and Conciliation Act provides for, under Section 34, grounds for setting aside an arbitral award. And it's very specific. Only under the grounds that are specified in the Act can an award be set aside. So if, for example, there was a diversion from the procedure that's laid in the arbitration agreement, that's a ground for setting aside. If you can prove bias by the neutral or the arbitrator, that's another ground for setting aside. So, but the Act is specific on what grounds you can rely on to set aside, and the courts have been very strict to implement only the grounds that are reflected in the Section 34 of the Arbitration and Conciliation Act. So as far the intention of the Arbitration and Conciliation Act is to promote arbitration, but also limit courts' intervention in the process. So that is why the Ugandan Arbitration Act under Section 9 says the court can only intervene under the sections that are specified. And one of those sections is Section 34, which provides for grounds for setting aside and maybe for interim measures and something like that. But otherwise, arbitration should be final and binding if it is done or conducted properly. I don't know if I would not simply be repeating what my colleagues have said in terms of, for example, gender. We face the same challenge, which we've signed the ERA pledge as ICAMEC, but I would encourage female neutrals to actually come forward, do the training. The space is available for females to come join. There's no restriction on the space. We encourage females to come join and be part of the neutrals. They will be appointed. As long as you have the qualification and you put yourself out there and you show that you have the expertise, you will be appointed. So if you're a female and you're worried about why other females haven't joined, maybe it's going to start with you so that, you know, you can encourage the other females to come join the profession. It's a very good profession, and I've personally enjoyed it, and I would encourage other females to do. As a center, I think a highlight as far as gender is concerned, our training faculty has an equal number of females as men. So at least on that end, we're doing great. I'm looking forward to the day where our panel is also balanced. So we try to encourage regional and local talents in East Africa and in Uganda. So we will work to give the regional people a platform to showcase your skills and talents. So if you have the skills, please go to our website, the ICAMEC website, apply to be a member of our panel. Once it's approved, you will be a member of our panel, but it doesn't only stop at applying. I need to re-emphasize this. Sometimes people apply and they assume that because they've been admitted on the panel, then they're going to be appointed. Being admitted on the panel is one thing, and an appointment is something else. You will only be appointed by people that know you. So you have to go out and showcase your skill set, whether it's through speaking engagements, whether it's through writing papers, whether it's through training other arbitrators. You need to make an effort to showcase your skill set so that when people are looking through the list of panelists or neutrals, they can identify you as someone who can resolve their disputes. Perhaps my parting shot, because I know time is not our friend, I recognize that despite the multitude of emerging African arbitration institutions, most African users seem to still prefer ICC and London Court of Arbitration. But my hope would be that Africa as a continent will see the value that its own institutions bring, because it's only by using the African institutions that we'll be able to provide a track record of the work we have done, or establish a reputation so that 10, 20 years from now, we can have the same reputation as these institutions, because our rules are as good as these other institutions. Our neutrals are trained by the same people. They have the same qualifications. It's only after Africans and East Africans, for that matter, take the opportunity to promote African institutions that then can we then be on the same playing ground as London and ICC, so that, the disputes that end up in London or ICC can be, administered by African institutions. So I think it's incumbent upon us to support our own homegrown initiatives. So yeah, those are my parting shots, and thank you so much for the opportunity to speak.
Thank you very much, Nora. I appreciate your comments and you taking the time to be with us this afternoon. Madeleine, any closing remarks, parting shots?
Thank you. For my part, I think, in parting, one, to thank the EAFLS for this opportunity, the ADR committee, the chair, Florida, for this particular program. For the Tanzanian Institute of Arbitrators, I think in terms of our future focus in building the infrastructure, a total revamp of the governance structure has been a journey that we've been embarked on since 3 years ago, and we look to have that task completed in about 3 months' time. This will lend us that credibility and respectability that the organization maintains, it being the oldest institution in Tanzania, that it was established in 1996, as I said earlier in my presentation. In terms of the international outlook, we are having the accreditation system relooked, and that would allow for not only Tanzanians, but also foreigners to be able to sit in arbitrations that are of Tanzanian nature. And I think that that would be the last part that I would want to share, because there is work in progress to create the environment that would build the institutions that are currently in Tanzania. Thank you.
Thank you very much, Madeleine, and thank you for your time and for your presentation and for your participation in this webinar. Dr. Masengo, do you have any last parting shot you want to make?
Yes, Igeria, I just want to
briefly, because we're running out of time.
Yes. Number one, Kigali International Arbitration Center is there as I can say the preferred center for settling commercial disputes through arbitration. I encourage people to put Tiaa's clauses in their contract for lawyers. I also encourage arbitrators to join its panels, both domestic and international panels. And I also want to invite them to our 10-year celebration conference, which is taking place next week for those who can do it. So the center is there and is doing very well. Thanks a lot.
Thank you. Thank you very much. And finally, Dr. Mutubwa, any parting shot you want to make as we wind up today's session?
Thank you, Arthur. Mine is to thank the organizers, but to also encourage colleagues from across the continent to look inward, to also look at our institutions, because they are the transactional lawyers who eventually write down which institutions will appoint arbitrators. Have faith in the institutions which you have nurtured, the institutions that have an African soul, institutions which understand where we have come from. The capacity in Africa is amazing. You will be surprised. We have some of the best people here. Mine is to also encourage lawyers, particularly those with the authority or with the ability to influence policy in government, to prefer African institutions. If you strongly feel that you want a foreign institution does not necessarily mean European. We can approach institutions in Kigali, in London, in Lagos, in Nairobi, in Tanzania, in Dar es Salaam. All these are competent institutions which can give you the best value for money. So I think the idea here is, let's begin this discussion. This is the first of very many engagements we should have as Africans, discussing how we move forward in terms of international commercial and investment arbitration. Thank you.
Thank you very much, Dr. Mutubwa. And with that, ladies and gentlemen, we come to the end of our webinar today. I don't know whether, David, you would want to say anything in closing. You have any comments to make?
Senior, I wouldn't want to say anything, just close it for us, just to say thank you to all of you.
Sorry, David?
Senior, I'm saying just to say thank you to all of you. You can close it.
All right. So thank you very much. I also want to register my appreciation to the Secretariat of the East African Law Society for putting this together and for bringing us all together for the publicity that this has been given, and ensuring that we're all, at the end of the day, well educated on matters relating to the arbitral institutions in our region. Thank you all for sparing the time, and I wish you a good rest of the evening. Thank you very much, and all the best. Our webinar is now over, and you may leave at your pleasure.